Your Honour, the accused is charged with 84 counts of breaking and entering and 1 count of stealing, per sections 418 to 419 and 391 subsection 1 of the Queensland Criminal Code respectively. Based off one form of evidence, the accused's oral confessions, the Crown must prove the accused satisfied all elements beyond reasonable doubt, as provided by Viscount Sankey in Wilmington and the Director of Public Prosecutions. With reference to Goldsmith and Sandilands, the defence accepts that the accused's oral confessions are relevant. However, permissible by section 590AA, we, the defence, will request your honour, per section 130 of the Queensland Evidence Act, to exclude the admissibility of the accused's oral confessions on the grounds of both public policy and fairness. Section 7, subsection 1 of the Police Powers and Responsibilities Act highlight Parliament's intention for police officers to comply with the Act in exercising powers and performing responsibilities under it. However, if I may direct your honour to the accused's oral testimony made in the back of the police car once placed under arrest, under Schedule 9, Section 26, subsection 1 of the Police Powers and Responsibilities Regulation, a police officer must caution a relevant person about their right to silence and warn them that anything they can say can be used as evidence. Such a right was not read out to the accused once arrested, nor was it electronically recorded per Section 435 of the Act. Before questioning, under Sections 418 and 419, a relevant person is entitled to be advised of their right to telephone a friend, relative, or lawyer concerning their whereabouts and ask them to be present during the questioning. Once arrested, the accused was immediately asked questions by police without being able to exercise this right. Moreover, Section 421 prescribes a police officer, before questioning starts, to allow a child to speak to a support person chosen by the child where the conversation will not be overheard. Your Honour, my client is not only 14 years of age, but is also of Torres Strait Island descent. Therefore, when also referring to Section 420, this only substantiates my client's prerequisite of having a support person apparent during questioning. Countless questions were directed to the accused prior to a support person being apparent, once placed back in the police car. As similarly seen in Aaron Adamic, such admissions to police, before being questioned, were inadmissible through the application of the principles adopted in Bang and Cross. If I may now direct your honour to the police officer's questioning at the station, the accused was accompanied by a social worker, Mary. However, as the accused did not know Mary, referencing Schedule 6 of the Act, Mary did not satisfy the definition of a support person, which includes for a child, a parent or guardian, a lawyer, a representative from a legal agency, or an adult relative or friend of the child who is acceptable to the child. Moreover, under Section 436, subsection 4, for recorded confessions during questionings to be deemed admissible under subsection 3, the confession must be part of the recording of the accused's questioning. Several sections of the Crown's professed confessions were marked as inaudible in their supplied transcript. Therefore, this evidence lacks cogency. As quoted by Justices Stephen and Aiken in Bunning and Cross, there are a number of instances where the accused's right to immunity from arbitrary and unlawful intrusion into the daily affairs of private life was impaired. Such deliberate disregard for the law by the police officers in obtaining their evidence was, as quoted by Chief Justice Barwick based off the judgment made in the Crown and Ireland, obtained at too high a price. Quoting from the Crown and Day and Anor, in order to deter police officers flaunting the law, whose task it is to uphold the law, upon weighing the public need to bring conviction to those who commit criminal offences, and the public interest in the protection of Indigenous children from unlawful and unfair treatment, we request for the accused's confessions obtained to be deemed inadmissible. As a final point, the defence wishes to exclude the oral testimony made by the accused under the fairness discretion, as established in the Director of Public Prosecutions in Christie and adopted in the Crown and Lee. Justices Wilson, Dawson, and Toohey in Vandermeer and the Queen provided that, in considering whether a confessional statement should be excluded, the question is whether it would be unfair to the accused to use this statement against him, obtained in circumstances which affect the reliability of the statement. Therefore, as quoted in Lee and adopted in Foster and the Queen, with reference to the conduct of the police and all the circumstances of the case, the defence submits the accused to have confessed under gratuitous concurrence. According to Chapter 9, Paragraph 4C of the Supreme Court Equal Treatment Book, 2nd edition, gratuitous concurrence refers to the tendency of a speaker, primarily of Indigenous descent, to agree with a proposition put to them by an authoritative figure, regardless of whether the speaker truly agrees or even understands the proposition. As a means of avoiding conflict with the police, the accused confessed of these charges. In addition, the accused's abrupt answers, shyness, lack of eye contact, and looking down while being spoken to are common signs of gratuitous concurrence being apparent. Despite the accused's confessions to have, as quoted by Viscount Simon and Director of Public Prosecutions and Christie, some tenuous ground for holding it technically admissible, on the balance of probabilities, the accused's confession would be more prejudicial than probative, as summarised in the Crown and D and Justice Thomas in the Crown and Hassler. Thus, the defence submits that it would be unfair to admit the accused's confessions, as similarly seen in the Crown and Casey. If Your Honour elects to disregard the accused's confessions, and subsequently, with reference to the Doney case, it cannot be said that the evidence against the accused is at an appropriate standard to sufficiently prove all the facts in issue, per sections 418 and 419 and 391 subsection 1 of the Queensland Criminal Code. On that note, Your Honour, the defence would thereby request a no-case submission.